Good morning. We're now on the record. It's 9 a.m. on Thursday, March 5th, 2026. This is an evidentiary hearing in proceeding number 25A-0500E, Black Hills Economic Development Rate, EDR, tariff proceeding. On February 19th, the Black Hills, on behalf of the parties to this proceeding, filed a unanimous comprehensive settlement agreement, which will be the focus, I think, of the conversation today. I'm Eric Blank, the chair of the commission. Can my colleagues introduce themselves for the record, starting with Commissioner Plant?
Good morning, Commissioner Tom Plant.
Uh,
Good morning, Commissioner Megan Gilman.
Thank you. Let's continue with entries of appearance, starting with the company, Black Hills.
Good morning, Mr. Chairman, Commissioners. Greg Sopkin, representing Black Hills Colorado Electric, LLC.
Trial staff.
Good morning, Chair. Good morning, Commissioners. Assistant Attorney General Ross Smith this morning representing trial staff. I'm joined by my colleague, Assistant Attorney General Josh Foreman.
Welcome. Thank you. UCA.
Good morning, Mr. Chairman and Commissioners. Senior Assistant Attorney General Gregory Bunker on behalf of the Utility Consumer Advocate.
Thank you. Welcome, welcome. Commission Counsel.
Assistant Attorney General Alex Acera here as Commission Counsel.
Did I miss anyone? With that, let's go to electronic process. We're going to conduct this hearing using electronic exhibits. A spreadsheet marked as hearing exhibit 500 lists most of the pre-filed testimony and attachments. With that, any objection from the parties to the omission of hearing exhibit 500, the spreadsheet listing all the exhibits? We'll get to the exhibits in a second. Mr. Sopkin, any concerns with hearing exhibit 500?
No objection, but as you say, there's a couple of settlement testimonies that will also need to be admitted.
Understood. Hearing none, exhibit 500 is omitted. And again, we'll get to gaps, but let's get omitted all the exhibits listed on hearing exhibit 500. Any objections to admitting all the exhibits listed on hearing exhibit 500? Mr. Sopkin, Mr. Smith, Mr. Bunker?
No objection.
No objection from UCA.
Okay, thank you. So all the exhibits on hearing exhibit 500 are now admitted. Mr. Sopkin, any additional exhibits such as the settlement testimony that you'd like to have admitted?
You bet, Your Honor. We would also like to admit hearing exhibit 106, which is the Black Hills settlement testimony of Michael Harrington. That includes 4 attachments. And if I may, I believe staff has also filed hearing exhibit 201, which is the staff settlement testimony of Jeff Fiedler.
Any objections to admitting those exhibits? Hearing none, so moved. Are there any additional revised exhibits that need to be moved into the record? Mr. Smith?
Yes, thank you, Chair. Staff just has one. We would like to, it was brought to our attention, and we've discussed this with the company, that Mr. Fiedler's settlement testimony had one oversight in it that we have corrected, and then we've placed it in our box folder. It's marked as hearing exhibit 201 Rev 1. That corrects the oversight that was made in that testimony. I'm happy to have Mr. Fiedler testify to that when he comes to the stand, or I'm opening it for admission now if there are no objections.
Mr. Sopkin, have you seen the revision and any concerns?
I'm aware of what the change is, and there is no objection, Your Honor.
Mr. Bunker, are you okay with the change?
Yes, I am. No objections from UCA.
Let's just admit that now. Mr. Smith, anything else on admission at this point? Since we have a unanimous comprehensive settlement agreement in front of us, depending on your view, Mr. Sopkin, I'd propose starting with a brief overview of the settlement agreement from the company to get us started. Is that consistent with your thinking, or would you prefer to just jump into the witnesses?
It's consistent with my thinking. We have Mr. Harrington as our witness supporting the settlement agreement, and he is prepared to do a walkthrough, a high-level overview of the settlement, if that's okay with you.
No, I think that would be very helpful for us. Does the legal assistant have a question, Ms. Federico?
Yes. Mr. Sopkin, I had asked you all you're going to need to file the settlement agreement as an exhibit if you wanted to display it because it wasn't on the spreadsheet. Which one of your exhibits is it, or have you not uploaded that yet?
The settlement agreement is attached to Mr. Harrington's settlement testimony, and yeah.
Was it MJH1 106 MJH1?
I believe that's right.
Okay, I just wanted to make sure since you were going to talk about it. Thank you.
Yeah, it's attachment A to his, I think, hearing exhibit 106.
That's right.
Thank you, Ms. Federico. Mr. Smith?
Yes, Chair. Just one just procedural point I wanted to raise here at the outset. Mr. Fiedler has informed me that he has an appointment at 1 o'clock, that he will be unavailable from 1 o'clock to 2 o'clock. I don't know if we will be here then. Part of me hopes not, but if so, I would just ask that if we start to get close to that time, if we need to take him out of time, I just want to make space for him to be able to do that, if that's not going to be a problem.
Yeah, I'll check with my colleagues in a few minutes, but I think there's no cross, and I probably only have maybe 30 minutes of questioning. So let's jump into the witnesses. For me personally, I have one question for Mr. Harrington. Then I have some highly confidential questions for Mr. Ahrens, and maybe a couple questions for Mr. Fiedler and Dr. England, but would be prepared to excuse company witnesses Hawkins and Thomas at this time. So Commissioner Plant, do you have questions for either of those two witnesses, or any guidance you want to give to Mr. Fiedler about whether we're going to get anywhere close to one?
No, I don't have any questions for them.
Commissioner Gilman?
Yeah, thanks. No, I don't have any questions for them, and my questioning is very limited. I would say probably 3 or 4 in total.
Okay. So with that, Mr. Hawkins and Mr. Thomas are excused. Commission counsel has let me know that at least for now, the advisors and counsel do not have questions for any of the witnesses. So Mr. Sopkin, any other issues before we call Mr. Harrington?
No other issues. We can call Mr. Harrington to the virtual stand.
Mr. Harrington, you out there?
I'm here. There we go.
Can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
And put your hand down. Is anybody with you or communicating with you in any way?
No, Mr. Chair, I'm in my office by myself.
If that changes, will you let us know?
Yes, I will.
Back to you, Mr. Sopkin.
Mr.
Harrington, by whom are you employed and in what capacity?
Yes, good morning. I'm employed by Black Hills Energy Service Company. I'm the Director of Regulatory for our Colorado utilities.
And Mr. Harrington, did you cause to be filed hearing exhibit 106, the settlement testimony of Michael Harrington, including the attachment, a settlement agreement, as well as, I believe, 4 other attachments?
Yes, I did.
Yep. Actually, MJH1 is the settlement agreement, and then there's MJH 2, 3, and 4. which are the settlement red line tariff, the settlement customer service agreement, as well as a letter of support. Is that correct?
Yes, that's correct.
Okay, well, at this time, we would ask Mr. Harrington to walk through the settlement at a high level.
Mr. Harrington, that'd be great.
Thank you. Thank you, Ms. Shopping. Good morning, Mr. Chair. Good morning, commissioners. I'll start back a little bit, if I might. As you all know, we had an electric rate case 2 years ago, 2024 electric rate case. And one of the things that we heard loud and clear from our local stakeholders was the impact of electric rates on economic development. You can go back and read the testimony. There's numerous testimonies from our local communities about that.
We remember, Mr. Harrington.
Okay, well, we won't relive some of that, hopefully. But one of the things we took away from that rate case was trying to find tools that we could use and develop to help economic development. And so one of the first action items that we did was work with some of our local stakeholders and the General Assembly and made some specific certain modifications to the economic development statute, which was passed last year in 2025 General Assembly. After that, we began working with the local economic development groups from PEDCO, the city, the county, to try to gather feedback on what are some of the critical, important tools that we can use or offer to help encourage economic development in Southern Colorado. Through those discussions, that led to the development of our economic development tariff. So many of the ideas and the concepts that we discussed with those local stakeholders were included in our economic development tariff, which we filed late last year. Turning through the proceeding, we worked with the 2 interveners. We have PUC staff and the consumer advocate. We're active and involved in this proceeding. We had numerous meetings with the parties, and thankfully we were able to reach a unanimous comprehensive settlement agreement, which is what we're here to talk about today. We made a few specific changes to the tariff in response to the parties' suggestions and in their testimony. I'm sure we'll cover a little bit in more detail, but a couple of the more notable changes were inclusion of certain other riders, like the RESA rider, the DSMCA rider, the Clean Energy Plan rider, including those. There was some ambiguity around how we would calculate the economic development rate, ECA, so the new ECA rate. There was some ambiguity from the parties on how we would calculate that. So we provided a little more information and detail on how that new rate would be calculated. We've added a numerous number of customer protections, kind of following a lot of the example that we have from Xcel Energy and their economic development tariff. We've added a number of customer protections and requirements that customers participate in certain programs if they're available. And then marginal cost is obviously one of the key factors in determining the economic development rates. So we have agreed here to update our marginal cost study every 2 years. We provide frequent updates to the commission on marginal cost, which helps ensure that the economic development rates are still higher than the marginal cost. That periodic update will help ensure that those rates are higher and comply with the statute. And then we've agreed to numerous other reporting requirements that also help demonstrate that any contracts that we might enter into an agreement with are above the marginal cost. So, Mr. Chairman, that's a high-level overview of the settlement. I'm sure we'll get into a little more details, but appreciate to be here and appreciate your considerations.
Thank you, Mr. Harrington. Commissioner Plank, questions for Mr. Harrington?
Good morning, Mr. Harrington. I just have a quick question for you. I'm apologize because I was just looking through to try and find out what part of this is potentially confidential, and I'm not sure. So I'll refer to it in vague terms, and maybe you can understand. So based on your RICE calculation, which is a portion of a certain capacity, I don't know if that capacity is confidential or not, but should that capacity calculation also include the 20% planning reserve margin as well as the direct capacity component of that total capacity of the RICE unit? So in short, should that number be 20% higher than the one that was used in the spreadsheet?
I think I might have to defer that to Mr. Aaron's, who kind of ran that capacity calculation.
Okay. All right. Well, I don't have any further questions. Thanks.
Okay.
That will touch on some of my questions for Mr. Ahrens too. So we'll see how far you get, Commissioner Plant. Commissioner Gilman.
Hi, good morning, Mr. Harrington. Yeah, just briefly question for you. Section 9 of the settlement, which I believe is on page 7, shows those system benefit programs or pathways, as you mentioned. Are you familiar with that? Yeah, it just starts there at the bottom. Perfect.
Yes.
Okay, great. So it's my understanding in the way this is phrased that a customer would only need to participate in or display a minimum of one of these. Is that accurate?
That's correct. Participate in at least one of these programs.
Okay. But you all don't have, or no one else has any influence about which they would choose. Just one, and any one they pick would be sufficient.
That's right. I mean, we don't have any customers, signed up yet. We haven't executed any agreements yet. So it's hard to say specifically what customers would participate in. I mean, based on this list, it's likely they would participate in several of the programs. The customers that we have been talking to, a lot of them were talking about, bringing generation solar behind the meter. It's likely that they would have battery storage. We're talking large load customers that have pretty high load factors. So most likely they would have a fairly high load factor. But it's hard to say exactly which customers, or hard to say what the customers would choose and what they would bring. But it's likely they would participate in multiple of these options here.
Okay. No, I mean, these look familiar, and certainly I think I understand the intent of a lot of them, but it seems some go kind of directly to perhaps more a direct kind of cost benefit. As we look at more favorable load shapes or load factors versus, say, installing perhaps one EV charger or uptaking one DSM measure, which may have just more limited impacts. So just trying to see if they really are all optional and tradable, or if you all are prioritizing ones that benefit the system kind of more directly.
Yeah, but we don't really have, it's not really listed in the settlement that we would favor one or the other, but I mean, I think when you're looking at impacts to existing customers, the load factor, the interruptible tariff, although that depends on the structure, if it benefits all customers or not. But the energy efficiency measures, those would have the biggest impact to the system. It's kind of, we call them the system benefit attributes. So I think we would look at those a little heavily rather than, just one EV charger in the parking lot. I think we would certainly favor some of the other items here that would have a bigger impact to the system.
Okay, but there's no mechanism as it stands to do that. Any of them would technically kind of check the box that's required here.
That's correct.
Thanks. Those are my only questions. Appreciate it, Mr. Harrington.
Thank you, Commissioner Gilman. Mr. Harrington, just one set of questions on timing. can we pull up your settlement agreement testimony hearing 106 at page 19? And clicking on the link in footnote 2, it sounds like there's one customer in particular that may have immediate timing issues, and you'll have to guide me through. Yeah, let's make sure we don't breach confidentiality, but I think this is all public. If you can click on that link, it looks like
9:20 a.m.
Yeah, thanks. It looks like there's Project Falcon that can bring up to 300 jobs well, we'll do it without the link. There it goes. Up to 300 jobs to Pueblo. Any comments, thoughts on that? Am I reading this right? You can scroll down. Yeah, there it is.
Yeah, a couple of comments. I think first, certainly when we're talking with potential customers, there's a lot of confidentiality. So we were careful here to provide really just only the public information. And so what this project is, as it shows here, it's a large manufacturing company that is interested in a new location in Pueblo. As you see here, it has the potential to create 287 jobs. As far as the timing goes, we have been in constant communication with the potential developer. So has the local economic development groups, PEDCO, and the city. I don't know how much more I can comment on the timing, other than we've made a lot of progress, and I think it is getting fairly close to being we've made a lot of progress. I guess maybe I'll leave it at that. There's, as with any of these large projects, there's a lot of moving parts. There's a lot of complexity to it. I can speak a little bit on our side from our behalf. We feel like we are in a good place for the electric service to the potential customer. But there's still a lot of parts that are still being worked on. But it's an exciting opportunity, and we're really hopeful that we can get this deal finished.
Can you can take this down? Is the commission's approval or consideration of this tariff from a timing perspective critical to this one customer?
Well, I would say that I think short answer is yes. As required in the statute, the electric rates must be a critical criteria for the customer to be eligible for the EDR tariff. And so the approval of the tariff is a critical concern for the potential customer, as with all customers that would be eligible. The specific timing date as far as within now or the next few months, that I'm not sure of. But I would say just generally the approval of the economic development tariff is a critical part for this potential customer.
I guess assume for purposes of this question that the commission may have some broader concerns with the tariff as filed. I think my colleagues have already mentioned too, and we'll see how the hearing progresses. But we also share the desire of the company, OEDIT, and the legislature to see large new customers like Project Falcon choose to locate in Pueblo. Any thoughts if this commission maybe approve the tariff for application, to this one large customer, maybe looking for immediate certainty, but perhaps depending on what happens today, try to address our broader concerns over time? Said another way, any thoughts if this commission set the megawatt tariff cap at 40 megawatts or somewhere else below 100 megawatts for now to support at least one or more large customers instead of initially approving it up to 100 megawatts? We could then look at raising the cap as our concerns were just any thoughts on that idea? And like you said, we'll see what Mr. Hearn says.
Well, I guess, yeah, a couple of comments. When we look at the language in the statute for the economic development, tariff rates, that it does not contemplate a cap. The some of the advantages for the standard economic development tariff is really speed to market, and allowing these customers or providing these customers with some level of confidence in what electric rates they would pay. That's really important to these developers when they're considering, site selecting and moving, and especially down to Pueblo. Having some certainty or a good understanding of what their rates are will help them make their decisions. So I kind of mentioned that a little bit to say that the value in the standard economic development tariff really comes from being able with certainty to offer customers an option. As far as limiting or capping the eligibility, Mr. Chair, I think we'd be open to some ideas, concepts, if there are further concerns about how close is the marginal cost, is how close the discounted rate comes to the marginal cost. I think we'd be certainly willing to consider some and maybe address some of your concerns if you have any. I think right now the cap the cap that the parties agreed to, we felt was a reasonable balance in trying to attract a few customers, and give us some tools to be able to attract a few of these customers. And so we think it's a reasonable balance, but I think we're certainly open to feedback and maybe suggestions we can take back.
All right, and just so I'm clear, staff suggested 80 megawatts, and the settlement agreement lands on 100 megawatts. So even though it's not in the statute, the parties did agree on a cap. Is that fair? Okay.
That's correct. Yes.
That's all I have, Mr. Sopkin. Redirect. Oh, you're on mute, sir.
Sorry.
There you go.
Mr. Harrington, first question involves Commissioner Gilman's questions to you about Section 9 of the settlement agreement, the system benefit participation, which lists a number of possible measures an EDR customer can take to benefit the system. Would the company encourage participation in more than one of those programs?
Yes, certainly we would. Our EV program, DSM, we have some good programs for customers to participate in our energy efficiency programs. Obviously, with the EVs, we've got EV incentives for EV chargers. So yes, we would encourage participation in more than one.
In your opinion, is it true that the higher the megawatt level we're talking about for an EDR customer, and the range here that we're discussing in this proceeding is between 3 megawatts and 40 megawatts, that an EDR customer with a higher megawatt load is more likely to have a good load shape and behind the meter renewable resources?
So certainly, as we're and I think it's important too for the commission to understand too that when we're talking of 3 megawatt to 40 megawatt, we're not talking data centers. So this is we've been trying to make clear that this is not a data center tariff. This is not a large load tariff that is of a lot of discussion currently right now. Really, what this tariff is trying to target is manufacturing type of companies to locate in Pueblo or Pueblo County. And generally, when you see a manufacturing facility between that 3 to 40 megawatts, their load factors are fairly high. So we would expect a fairly high load factor higher than 80%, most likely up into the 90s. Depends on the type of industry and how often they run their shifts, but we would anticipate a fairly high load factor.
And just as an aside, any customer with more than 40 megawatts of load or wants a contract of longer than 10 years, that would involve the company having to come to the commission and get specific approval of a customer-specific contract. Is that correct?
That's correct.
And is one of the reasons why the company, I guess, didn't want a hard line on these system benefit participations was because some of the customers might have that smaller load, say 3 megawatts, and have a more difficult time with those issues.
Certainly, I think one of the options that we listed was the interruptible rider. That can really vary by customer. Sometimes we see it does provide system benefits. Sometimes it doesn't. And so we didn't want to make these hard requirements because it may not actually provide system benefits. So and certainly some of the smaller customers, if we're looking at a 3 megawatt customer, their load shape, their profile, their business structure could be very different. That one or two of those items on that list might not really be applicable.
Okay, and then moving to Chairman Blank's questions of you. First question is, if we could pull up attachment MJH4 to your settlement testimony, hearing exhibit 106. Now, Mr. Harrington, this is one of the attachments to your settlement testimony. Is that correct?
Yes, that's correct.
And the letter indicates in the first paragraph that the letter's from Quest Site Solutions, that Quest Site Solutions assists companies in deciding where to locate facilities. You see that?
Yes, I do.
And then the beginning of the second paragraph, Quest is currently conducting a multi-state site selection search on behalf of an international company for a new manufacturing facility. My question is, to your knowledge, does this relate to the same Falcon manufacturing facility that questions were being asked about?
Yes, it is. This is the same project.
Okay, and if you could just read the remainder of that paragraph too.
This project is for an industry that is not currently present in the state of Colorado and would have immense economic impact for the community. Due to the significant use of electricity in the manufacturing process, electric rates are a key decision criteria for this project.
Okay, and would you say, without revealing any confidentialities, that this project has progressed far enough that, to your knowledge, it would be important for this customer to have a timely decision on the EDR tariff?
Yes, I would agree with that.
Okay. And then there was a question about the cap. And as Chairman Blank alluded to, staff had initially proposed an 80 megawatt cap, and the company came back with a 100 megawatt cap, which both of the other settling parties agreed to. Why did the company propose a 100 megawatt cap?
Well, it's, generally aligns with some of the capacity resources that we've been studying and looking when we've been looking at marginal cost capacity resources. Generally, what we're looking at are facilities around 100 megawatts. Certainly, the Rice facility that we used could go smaller than that. But generally, when we receive bids from developers, from our electric resource planning, the 100 megawatts is generally around the type of size that we see. We certainly get bigger bids, but so we felt like 100 megawatts was a reasonable a reasonable tie to projects that we've kind of studied recently.
And as a hypothetical, if the initial EDR customer that comes in through the EDR tariff has a load of, say, 35 megawatts, and the commission were to impose a 40 megawatt cap, would that mean that the company would likely have to come in fairly quickly after that, of course, depending on its EDR successes, to seek a variance?
Right, that's correct.
And what, to your knowledge, would need to happen as far as that variance request?
Well, I think we would have to request, an additional, or the cap to be raised, or an additional, yeah, we would have to request the cap to be raised, which, I think understand the concerns about, marginal cost and where that comes. I think there needs to be, though, a balance between what the intent of the statute is, which is to provide for timely execution of these standard contracts. And so, if we happen to get a 35 megawatt customer in the near future, the next customer would have a very lengthy delay. And that's what the statute and the economic development statute is trying to avoid. And the intent of that is to allow us to have a standard option to attract customers on a timely basis.
And in a variance proceeding, as you understand, that could turn into a full-blown litigated proceeding before the commission that could take, say, 9 months to resolve?
It certainly could turn into a full litigated proceeding. We see those often. As far as the exact time, I know this, for example, this proceeding is on an expedited time. I would have to defer to my legal counsel as to whether or not a request for a cap increase would be the full application, or if it could be more of an expedited time. That I'm not sure of. But it certainly would require, a proceeding before the commission and have to get a decision on that, which would take time.
And the company in its filing did not propose a cap. Of course, staff did, and the company, as a matter of compromise, did agree to a 100 megawatt cap. But do you see anywhere in the statute that requires such a cap?
No, there's not a standard in the cap, or there's not a language in the statute that requires a cap. And I think also with the periodic update of the marginal cost study, that would provide checkpoints, regular checkpoints, to show that, okay, we're still, our EDR tariff is still above the marginal cost. So I think there's some checkpoints that we built into the settlement agreement that provides that commission that review period periodically.
And if the commission does want to impose a lower cap, would the company be much more comfortable with what staff proposed, an 80 megawatt cap, than a 40 megawatt cap?
Yes.
Those are all the questions I have, Mr. Chairman.
Thank you, Mr. Sopkin. Mr. Harrington, you may be excused. Ms. Federico, well, let's see, Commissioner Plant, are your questions for Mr. Aronson highly confidential or just normal?
I think to be safe, I'd do them in the highly confidential.
Okay. Let's, Ms. Federico, what do we need to do to get to a highly confidential session? I think the existing parties are the right ones, but can you guide us? Do we need like a 5 or 10 minute break?
At least 5 minutes, because I'll have to turn off the stream and the recording. But yes, I will also need Mr. Sopkin or someone else from Black Hills to review all of the participants that are in the Zoom and tell me if any of them can't be here.
Okay. So let's, Mr. Sopkin, did you want to add anything?
Yeah, I would just ask the the persons appearing on this Zoom call to cooperate here, and if they have not signed the highly confidential agreement, to not join that session. We will, of course, do our due diligence and try to check in this quick period of time, but I think everybody knows who's on this call who has in fact signed the highly confidential NDA.
I think we only have 16 people on the call, Mr. Sopkin, so I think it's going to be pretty straightforward for this one. Let's take a 10-minute break till 9:50, and then we'll put Mr. Aarons on the stand and keep going with Commissioner Plant. Thanks. 9:50. right, we're back on the record in 25A-0500E at a highly confidential session. Mr. Sopkin, redirect.
Thank you, Mr. Chairman. Mr. Ahrens, referring to Commissioner Plant's and Chairman Blank's questions to you, there are a number of methodological questions about how the company came to the conclusion that the proposed EDR rate is above marginal cost. You recall those questions?
I do.
And at one point, I believe during those questions, you indicated that, with the methodology you used, you believe that the EDR rate is above marginal costs. And I believe you suggested even with using a 15% reserve margin. If you could please just walk us through why you believe that this record that we have in this case still demonstrates that the company's proposed EDR rate is above marginal cost.
Yeah, if we could pull up that attachment to my testimony, that is the executable work papers.
Sorry, that's the one we just had up that's highly confidential, right?
It is the same, yes.
Okay, can you tell me which tab to be on so I'm not inadvertently on the tab that is confidential?
Yeah, it's going to be marginal cost summary, I believe is the tab. And if you could just increase the size a little bit. Thank you. Looking at the capacity marginal costs, for example, if you look at cell D10 with that 3118 number, if you were to multiply that times 1.15, you would get a number that's about let me do it real quick. So you get a number about 3536. Now, if you go to the customer cost savings tab, if you scroll down, okay, right there. So if you look at the number that's in cell E101, that 0.03118, if you're to add 4/10 of a cent to that, which is the increase that results from adding the 15% for the reserve requirement, you would then get a marginal cost of 0.03435, right in that range. If you compare that to what's in cell G97 of 3.8, you can see that the effective discounted EDR rate is still about 10% higher than what the marginal costs are. And that's essentially what we're using to demonstrate that the proposed discounts are above marginal costs.
Okay, and in your testimony that was submitted in this case, and maybe UBA's testimony as well, but did the company present evidence that with the methodology it used, that there would be some headroom between the EDR rate and marginal cost?
That's correct. We're not proposing to discount the rate down to marginal cost. We're making sure that it's above marginal cost. The result of that is that other customers receive benefits.
Okay, and even with the issues that have been pointed out by the chairman in his questioning, and with you applying a 15% reserve margin, are you still confident that the company's EDR proposed rate will be above marginal cost?
Yes,
Okay, and do you believe that just looking at the first year by itself is appropriate?
I don't.
Why not?
The costs go down over time. If you look at only the first rate, it's going to be higher. The marginal cost will be higher for that 1 year. Granted, we are looking at contracts that are likely going to be at least 10 years, 10 years for under the EDR. But certainly the customers that we're talking about, if you look back on what was discussed about Falcon, they were talking about a 25-year life. So the advantage of that is that after the 10 years, they would go on the standard rate and result in additional revenues. There's a lot of benefit to bringing on a customer that's going to be here for a while.
Okay. And with regard to the settlement that was reached in this case, did the company fully explain its marginal cost analysis to the other settling parties?
Yeah, we did. We met with the parties before we filed to describe what our methodology was going to be. We provided those attachments as part of our filing, and in answer testimony, I don't think any party had challenged the marginal cost studies.
All right, and then as far as the settlement reached and the descriptions contained therein, as fully described in the settlement testimonies, is it your understanding that the other settling parties were fully comfortable with the marginal cost analysis that the company performed?
Yes.
Okay, and with regard to the discounting of revenues over time, and I'm not going to ask for any precision here, but would you say it's fair the company does not expect to wait 8 years to file its next rate case?
I think it's fair to assume that we will not wait 8 years between rate cases again.
Okay. And then looking again to the settlement agreement, and specifically Section 9 system benefit participation, there is a listing, and this is I believe it's MJH1 to the settlement testimony. If we could pull that up, which is Exhibit 106, MJH1. Okay, looking at Section 9 system benefit participation, each EDR customer must participate in at least one of the following system benefit activities unless unavailable to the customer. The first one is maintain a favorable load factor above system average. And my question to you, Mr. Ahrens, is would the company be comfortable if the commission imposed a condition that in order for this EDR rate to apply, that the EDR customer must maintain a load factor above system average, or even maintain a load factor at 65% or above, or in the alternative, the company would have to seek a waiver for that customer?
Yes.
And in that event that there's a customer who would like to take advantage of the EDR, but has a load factor below 65%. In that case, would the company be willing to agree to file for a variance to show with respect to that specific customer that the EDR rate proposed is above marginal cost?
Yes, I think that's a great way to resolve some of the issues that were raised earlier.
And would the company in such an event hope for at least an expedited consideration of such a waiver application?
Yes.
Okay. Your Honor, those are all the questions I have. I would simply note that in this case, the commission requested supplemental testimony, which we provided, and then second supplemental testimony, which we provided. There obviously have been a number of questions that have come up during this proceeding. I can say it's an understatement that the company would be disappointed if we have to start over and this entire thing were rejected. We are certainly happy to provide further information to the commission. We would certainly like a positive result, certainly as close to the settlement agreement as possible, so that the company can in fact seek this growth through EDR rates.
Understood. Thank you, Mr. Ahrens. You may be excused.
Thank you.
Mr. Fiedler, are you out there? Can you hold up your right hand?
Sorry, could you just give me 30 seconds to disconnect all my electronic stuff so I can answer that question correctly?
Yes. I didn't see that as a challenging question, but
you caught me by surprise there for a second. Sorry, just give me 1 second here.
Yeah, take your time.
Okay, all good to go.
Can you, yeah, thanks. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes.
Back to you, Mr. Smith.
Thank you, Chair. Good morning, Mr. Fiedler. And could you just go ahead and tell us for the records how to pronounce your name so that we're all doing it correctly?
It is Fiedler.
Fiedler, got it. I just did it wrong. I said that and I just did it wrong.
I
so
think
I
I was
apologize.
closer to you,
I
and
know
I'm
you pretty
tone
well.
deaf.
Could you please state and spell your name for the record, please?
Yeah, Jeff, Jeff, and last name Fiedler, Fiedler.
Great. And by whom are you employed and in what capacity?
Employed by the PUC as trial staff.
And did you cause to be filed in this proceeding what's been marked as hearing exhibit 200 and 201, and that's your answer testimony and settlement testimony, respectively?
Correct, yes.
And did you also cause to be filed hearing exhibit 201 Rev 1, which is the corrected settlement testimony?
Yes.
And do you have any further corrections that you'd like to make?
No, just that one small correction is filed, yeah.
Perfect. And as you know, we're here to discuss unanimous comprehensive settlement agreement. Were you a participant in the discussions that the result of which was that settlement agreement?
Yes, I was.
And you represented trial staff in those negotiations?
Correct, yes.
And then one last question. In your opinion, is the settlement agreement as it is written just, reasonable, and in the public interest?
Yes, I believe that, yes.
Thank you. That's all my questions. Chair Blank, the witnesses ready for questions.
Commissioner Plant?
I have no questions for Mr. Fiedler.
Commissioner Gilman, I know you were having some issues. Do you have any questions for Mr. Fiedler?
I don't have any questions, thanks.
I just have a couple. Did you hear the highly confidential session with Mr. Ahrens?
Yes.
Okay. And look, I know this thing's on a really short time frame and we'll stretched to the max. But did you personally independently review hearing exhibit 102, attachment DSA 1, in reaching your determination in the settlement agreement to agree that the revenues exceed the marginal cost?
Yeah, I and along with other trial staff, colleagues, did review that. Yeah.
Do you think it's appropriate to discount the costs for the time value of money, but not the revenues?
I have to say, I mean, I totally see the question that you're that you're getting at there. I mean, I think that would be an interesting analysis to see done. It didn't try to do that in real time with the executable file. I would just add, I was somewhat impressed by the company's willingness to, sort of make some concessions on the fly in this hearing to try to, further ensure that, that standard of relative to the marginal cost is met. So I mean, I do feel like they're really trying to assure us of that.
I mean, do you take the point that $8 million in revenue from a EDR LPS transmission customer is way below the, I mean, again, it's first and capacity cost. Does that cause you pause about your conclusion that the marginal revenues exceed the marginal cost? I can't imagine a growth rate that's going to make that net present value work.
Again, I want to be careful without sort of like seeing, like just commenting on the fly on that. I think some of the challenges in sort of reviewing that spreadsheet, and the proposal itself, I think, are that we don't know what the actual customer is going to look like. And I think, some of the discussion about like what will the load factor be, and we and other attributes of the project. I mean, it makes it, to my mind, it makes it hard to poke too hard at that spreadsheet. I mean, we should analyze it. And I see your point, but I feel like it's going to depend so much on the exact attributes of the customer that wants to enter into a CSA.
Do you think it would be appropriate to include a planning reserve margin in the analysis?
Yeah, I followed that discussion. I mean, again, I think what the company is offering seems like as I understood them to be offering, I should say, seemed like a good compromise here. I mean, yes, I think some planning reserve would be like a conventional approach to sort of how you look at additional capacity that needs to come on to serve that load.
Any thoughts about modifying the tariff cap to support potentially that one what looks like a fairly compelling economic development opportunity with Project Falcon in front of us, but taking maybe another look at the tariff for anything beyond that?
Sorry, could you say that again? I didn't quite follow there.
Any thoughts about modifying the megawatt cap on the tariff to support maybe Project Falcon, but then taking another look in some procedural mechanism to extend the tariff beyond that?
So if I'm understanding that right, like maybe lowering the megawatt cap to allow Falcon in, but then have an opportunity to review some more.
Yes, that's the idea.
Yeah. I mean, that certainly meets that goal of not, delaying the project that seems to be, well into some concrete discussions. I think that's hard for me to answer, not knowing what else might be quickly in the wings. You know, that I not to dodge the question, but that might be a better question for the company if they, if they have a sense of what else might be, rapidly approaching. Again, I just sort of hate to, as I think staff said in testimony, written testimony. I mean, we're very sympathetic to the economic development need in this region, and that's the purpose of the statute, right? Right. No, not that anyone isn't, but just do want to be, really mindful of slowing things down to the point where a project might fall through, in lowering the cap. I feel like that cap as proposed in settlement, that's not a lot of economic development projects coming through. And to expand on that a little bit, I think something we wrestled with in testimony and we explained this is that Black Hills is such a relatively small system, say compared to public service, that it's hard. It's just hard to know where to set that cap where you actually allow a good number of projects in for consideration and not have a sort of megawatt cumulative load impact on the system. It's frankly just hard to know where to set that limit. Again, to elaborate on that, in testimony, like if you sort of proportionally applied the PSCO cap, it would be way too small. So we're sort of we are in territory where there's potentially going to be more cumulative megawatt load sort of as a proportion of the system than was contemplated in PSCO. Sorry, I think I'm struggling to answer your question. I really hesitate to set the cap lower, knowing that that's going to put some delay on other projects.
If I represented to you that Black Hills peak demand was roughly in Colorado was roughly 450 megawatts in 2025, would you have any reason to doubt that?
No.
And so this is a big piece. 100 megawatts is a big piece for this utility. It's a 20% increase.
Yeah. Yep. Agreed.
That's all I got. Mr. Smith, redirect.
Thank you, Chair. And Mr. Fiedler, I just have a couple of questions here that I just want to kind of clarify a couple of points. And I think you alluded to this, and I want to be sure we discuss this. Do you believe, is it your opinion as a representative staff that having data regarding this EDR tariff, once the rate has gone into effect for some time, could that be beneficial to answering some of these more sticky, detailed questions? Do you believe that would be helpful?
Yeah, I think absolutely. We'll see how actual data from the system as a whole, and as I was saying before, so the attributes of the actual EDR customers, will play out. So yes.
And given that this is, we're sort of entering in, I think it's fair to say we're entering into relatively unexplored territory, particularly with this utility regarding an economic development rate. Is it fair to say that the contemplation here is that this would be iterative over a span of time? In other words, that as we go along in the process, we've contemplated or the parties have contemplated updates and changes as necessary.
Yeah, and I think this, if this is responsive to that question, the settlement agreement has quite a lot of elements of quantitative updates, various reporting provisions. Yeah.
And am I correct that the purpose of those reporting requirements is to ensure that the parties, the commission, are given as much information as possible regarding the outcomes of the implementation of the EDR?
Yeah, absolutely, exactly.
Okay. And then just one last thing. The settlement agreement, if we take it as a whole, um, given sort of the questions about the settlement that have come up, some of the changes that the company has agreed to, does staff continue to maintain that this is a just and reasonable compromise of this issue?
Yes, we do.
And as a whole, is it generally your opinion that the reasonableness of the settlement does that outweigh in some regard the exclusion of revenue in hearing exhibit 102, which I believe the chair alluded to?
Yes.
Well, thank you, Mr. Fiedler. I have no further questions.
Thank you, Mr. Fiedler. You may be excused.
Okay, thank you.
Dr. England, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No.
And if that changes, will you let us know?
Of course.
And you are a doctor. I got that right, don't I?
Indeed.
Okay. Mr. Bunker.
Thank you, Mr. Chairman. Dr. England, would you please state and spell your name for the record?
My name is Scott England, last name England.
And could you identify your employer and position title?
I am employed by the Colorado UCA as an economist.
And in this case, did you cause to be filed hearing exhibit 400, your answer testimony, and attachments SEE1 through SEE10 on behalf of the UCA in this proceeding?
I did.
And do you have any corrections to your testimony or attachments?
I do not.
And if I were to ask you the same questions today as contained in your answer testimony, would your answers today under oath be the same?
They would.
And did you participate in the settlement negotiations in this case on behalf of the UCA?
I did.
And since hearing exhibit 400 and attachments SEE1 through SEE10 have already been admitted, Mr. Chairman, Dr. England is available for commissioner questions.
Commissioner Plant.
I have no questions for Dr. England.
Commissioner Gilman.
Sorry, no questions.
Thank you. I guess, Dr. England, did you hear my questioning of Mr. Ahrens on hearing exhibit 102, attachment DSA-1?
Yes.
Again, I know I'm just asking you the same questions I asked Mr. Fiedler. I know this case is on a very short time fuse and that we're all stretched really thin, but did you independently review that exhibit in reaching your determination to support the finding that the revenues exceed the marginal costs?
My analysis went to make sure that the EDR rate was greater than the marginal cost. And it has been attested by the company that the rate they were proposing was somewhere around 25 to 40% above marginal cost, depending on the rate class in question.
Do you think it's appropriate to discount the cost for the time value of money, but not the revenues?
I'm a big proponent of consistency. So what is done to one side should be done to the other.
Do you think it's appropriate to include a planning reserve margin in the analysis?
I think that is something the commissioners could consider. I don't know whether it is a requirement of an EDR customer to have that imposed on them, but UCA would not be opposed if that was an additional component.
Any thoughts about modifying the tariff cap to support potentially the one economic development opportunity that Project Falcon that's most advanced, but then taking a harder look at the other elements of the tariff consistent with the concerns raised at this hearing? Any guidance or advice on that?
So would that be in regards to the megawatt cap?
Yeah.
I share your opinion that 100 megawatts is a significant portion of Black Hill's existing system. So there's probably some flexibility in what that cap is set at. I would share the concerns of the other parties that any modifications to the tariff could cause an obstacle in any ongoing conversations the company may be having with other potential EDR customers.
That's all I got. Mr. Bunker, redirect.
Thank you, Mr. Chairman. I don't have any redirect questions.
Dr. England, you may be excused.
Thank you.
I guess a couple questions, maybe Mr. Sopkin. Would you be willing to get a transcript of the hearing and see if we get it as a non-confidential document?
Yes, of course.
Okay. I'm not sure exactly where to go from here. I know we're all struggling on something that's on a way tighter time frame than usual. Uh, do you have any advice about the best path forward? I mean, I'm certainly don't want to get in the way of 287 jobs in Pueblo.
Yeah.
But I think at least I personally have real concerns with the analysis supporting, that core statutory determination. So, do you have any advice on process, Mr. Sopkin? Do you want further guidance from the commission? Do you want an opportunity to do a statement of position? I'm not even sure when the 120 days runs or what the exact statutory deadline is. And I didn't know exactly how this hearing would go.
Yeah.
Any guidance for us?
Well, I couple things, I guess. We certainly have no objection to filing a statement of position. And if you want certain issues addressed in there, we probably have a pretty good idea from what just occurred.
I don't have anything to add to my
Right.
current questioning, and we'll see if commissioners plan are going. Well, let's do that now. Commissioner Plant, you raised issues about the planning reserve margin. Are there other issues you'd like to see addressed in a statement of position?
No, I was satisfied with the company's answer on that.
Okay. Commissioner Gilman, I know you raised issues on load factor, which I share and may like to see further guidance. Any other comments on that?
No other comments. I think it's helpful, the elaboration today. So if there's anything to add on that, on the SOP, what the company's willing to do on that, I think that's helpful, but I don't have anything beyond that discussion.
Mr. Sarah, Mr. Davis, any guidance about process going forward? Just set a statement of position deadline, see what we get from the parties, and then see if we can deliberate on an accelerated basis. Guidance.
I think that makes sense. It sounds like the parties understood the areas of concern and, would look to address that in the statement of position. So I think that that's a fine way forward. And once those roll in, we'll meet with you and we'll figure out when the deliberation should be.
Mr. Sopkin,
Yeah, so a couple things, Your Honor. I'm looking at we believe that the PUC order is due April 16.
okay.
And I think we had originally suggested a statement of position on March 20. As a personal matter, I'm out of the country the 11th to the 18th, but if we want to stick with that, I'm sure I can make it happen.
Yeah, I wouldn't do it any later if you want to
Yeah,
hit
got
that
it.
deadline.
And what I would envision, if it's okay, is for us to, for example, I think you heard on the record, we're fine with putting in a 15% reserve margin. We're also fine with having a, some type of minimum load factor of 65% without a variance. And we could, kind of do the math on that and provide that as part of our statement of position, if that makes sense to your honor.
Yeah, that'd be great. And if you have any guidance on potential caps on the megawatts,
Yeah,
I think that would be helpful to me.
we
All
would
right.
address that as
What was the deadline? You said March 16th?
April 16 is the PUC order deadline according to our computation, and what we had agreed to in the procedural schedule was a statement of position on March 20.
Okay. Mr. Bunker, Mr. Smith, are you all right with an SOP due on March 20th?
For the UCA, just one question, and I don't mean to cause problems for the court reporter, but when would we anticipate seeing the transcript? With March 20 being 15 days away, I would think that's plenty of time, but just wondering about that.
Ms. Belay?
Yeah, this is Tracy. I would have no problem getting the transcript to you on an expedited basis.
Thank you.
Okay, thank you. With that in mind, no problem with March 20th or the deadline as we discussed, April 16th for your decision.
Mr. Smith?
No, Chair, staff doesn't have any issue with that deadline. I would just ask if it's possible, maybe, and I may be the only one here that needs this edification, but are you able to just quickly, for the record, recap the things that, like, sort of just a bullet point numerical list of the things that you would like to see specifically addressed in SOPs?
Yeah, whether the appropriateness of discounting costs by the time value of money, but not the revenues. The lack of analysis about lower load factor customers beyond what the company analyzed. And I mean, to me, it's probably a 20% reserve margin, because that's the reserve margin that comes out of, I think, a 2023 settlement. And then if there's, given that the evidentiary record is going to close in 5 minutes, is there a cap that lets, the one or maybe two, I don't know, high priority customers on this record? There's only one customer that, had been through the OEdit process and maybe so far advanced that we don't somehow mess up, but gives us an opportunity to potentially adjust the tariffs going forward.
Okay. Thank you, Chair. I really appreciate that. I think that's very helpful to kind of have all of that in one spot there. Thank you.
Mr. Sopkin, anything further before we close the record and adjourn?
No, I just want to thank you for your time and attention to this.
Yeah, thank you. Appreciate the responsiveness to the supplemental direct requests, and just appreciate we're not used to dealing with things this quickly, and we're doing our best. And we have an enormous amount of other things going on at the same time. So, Commissioner Plant, final thoughts before we adjourn?
Nothing much. Thanks a lot for the proceeding today and for the work on the settlement. It's appreciated. And thanks.
Commissioner Gilman. No worries. Just echo Commissioner Plant's comments, and thanks to the legal assistants and the court reporter and to the parties. And we'll look for the statement of position on March 20th and try and get you a decision before April 16th. With that, thanks. The record is closed and we are adjourned.
Thank you.
Thank you.
Thank you.